You are a smart woman who has done stupid things. And I believe it has something to do with your heart. I'm not discouraging you. I can't tell you who to love and who not to love and who to get into relationships with, but you seem to have had a great life, doing great things, being a very strong, independent woman who can accomplish so much. I didn't know you did that. You and your husband built that winery. It's amazing. But for the fact of probably the divorce and that downfall, you most likely end getting in and going the opposite way. And you most likely probably would have built the building in Grantsburg into a thriving business. I don't know what led you down the road to substances. I have ideas, but it makes me sad as a person and as a judge to see somebody who was thriving so well in life and doing well and hit a huge rough patch. There's a rough patch there. Because in reading the things that I had to with your divorce, whatever happened in your marriage and how you, happiness, not happiness, fights, not happiness, the divorce was tumultuous. It was brutal. That's what I gathered. And so it's really hard, I'm sure. It's like a death. And it affected you. It affected your children. Don't let it destroy you. And I know it's hard to see. And for a person that you looked in their eyes and you said, I do forever, and you loved him immensely, to go from that to where you were in your divorce, I can see that pain. And that is trauma. Absolutely no excuse, no reason to fall into substances. Absolutely no reason to start to build a lab, for substances. I'm going to tell you, I never paid attention or heard of dimethyltryptamine until this case. But I'm going to tell you, once I heard dimethyltryptamine, DMT, I now hear it in shows. And I hear it and I say DMT. I'm sure I've heard it before, but it never clicked because I've never had to know what it was before. I'm glad to learn about it. I knew about it to the extent of it's all legal things you can buy on the internet. You can do those things, but it's once you start to manufacture it and bubble it and then make it into the crystals, that's where it's illegal, because it's a substance. It's an illegal substance and it's a lab. I can see that this has had a significant impact on you and your whole life. I believe Ms. Landgraf stated you are going to start anew. You have to start fresh now. You don't have clothing, you don't have furniture, you don't have anything because you were arrested from that building. You were brought here. It's been 344 days. And now you're a convicted felon. Again, that pains me as a person and as a judge to know that somebody who did such great things in her life got to this place. And I'm hoping, and I think it's going to happen, that because you've had your epiphany in custody, you've had your time to become sober and have the substances, all of them work their way out of your system. I'm confident that you are going to have even more epiphanies. You are going to grow and you are going to become somebody else who can do what's written in the black and white from the memorandum versus the black and white of the criminal complaint. I'm just going to say, no man, no love, no anything is worth your self-respect, your criminal record, your life.
I made the choices. They were my choices. And I just didn't want to feel.
I understand that. I get that.
And I know that it was wrong.
You are owning that. I understand that, and I get that. It's just hard for me to read who Laura Michelle Chamberlain was and to think that she would have made those choices even with the impact that her life was having, but for other factors. And I understand the heart, I truly do. But I also understand strong, independent women and those that need to continue to rebuild and look out for themselves. Because it's your life, it's your children, it's your grandchildren. I don't think that the communities would be hurt or at risk if I put you on probation. You have no criminal history. Again, this was the worst, most terrible time in your life, and you made the worst, most terrible choices. So what I am going to do is I will adopt that deferred judgment of conviction that'll be in place, and you must do all of those things. I'm going to tell you the number one reason I see the state asking to terminate and revoke that agreement is, and to have me sentenced on those felonies, is the payment of $150 within 60 days. Get that done.
Yep.
Get it done immediately. Do your AODA assessment and make sure, even if you have to hand walk the documents to the district attorney's office, that they have that documentation. Because I don't want to see those little things. They're not little, but they're little compared to other factors. Those things be the reason why you face going to prison. With regards to the possession of methamphetamine, I will follow the recommendation, 3 years of probation. Generally, I would think, and I have in other cases, that 3 years, that's a lot of time to be put on probation for your first criminal offense. But this is a doozy. This is your first criminal offense, and they're felonies. And you obviously need some help. And it's unfortunate that it has to be in a way that the Department of Corrections will be watching over you and the state will be watching over you. But I want you to get back to who you were. Again, before this memorandum, I would never have guessed, just knowing the black and white of the criminal complaint. Okay? You deserve to be back to Laura that you were meant to be, that your family deserves you to be. And they want you to be. So 3 years of probation. I'm not going to do a withheld sentence because I'm going to tell you if she's going to be revoked, she's going to be revoked. And then she's going to be sentenced on the other matters too. Because, I'm second guessing that. No, I will do a withheld sentence. Because if you are going to be held and it's looking at being revoked, then you will be in custody, and it's not going to matter because I'm going to have to hear arguments for 3 serious felonies. And quite honestly, I'm not prejudging or pre-saying anything I'll do, but it's all same date, same time, same place, same things. So I can't see why there would be, at least in my mind right now, consecutive sentences. Conditions of probation. Absolute sobriety, that AODA assessment and the follow through, the mental health assessment and follow through. You need to work through some of that trauma. Regular testing, no alcohol, because that's absolute sobriety. Gainful employment. And I am going to add 20 hours of community service. Done good for your community, and from all respects, I would think that you were respected from the community, and perhaps this could be something that has let them down. So just give back a little bit. So 20 hours. I don't think that's too much. I think you can do 20 hours in the first year. All right. 343 days of jail credit.
Judge, I think she gets credit for today because she's not going to be,
I can pull up the case. Court of Appeals case says you do not count date of sentencing.
Oh, okay. I thought that was only if like you're continued to be in incarceration because the DOC counts that.
I don't believe so. I don't know. If you want to show me, that's fine. Otherwise, if she's revoked, I'm going to tell you, DOC is going to tell me I need to add days or minus days or all of those things. So you have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. The jail make sure that they have that. At least with the methamphetamine, you have the ability to request it be expunged through a written letter to the Department of Justice. With the other two hanging out there, they kind of have to wait to see. $518 in fines and fees for the possession of methamphetamine. I can't recall if it was asked or stated that she does better with her mom and to live with her mom. Was that even a request?
I can't live with my mom. She
Okay.
won't let me.
What's your plan?
Well, I will stay at my mom's for a little bit, but once I have a vehicle to find a job, find a place to live.
Okay. All right. Well, I will say that the $518, I'm just going to say DOC can collect that. We'll worry about that later. I think that covers everything. Oh, if the deferred judgment of conviction gets entered, okay, not right. Oh, yes, no, you have been a possession of methamphetamine. Again, let you know, no voting until your civil rights are restored. No longer able to use or possess a firearm for life. So hopefully you weren't a hunter. Mr. Schmidt, what am I missing?
Nothing from me.
Ms. Landgraf.
I've already went over her post-conviction rights with her, so I don't think that there's anything else.
All right, well, good luck, Ms. Chamberlain. You must report to probation immediately when you are released from custody. I need an address. Do you know your mother's address right now?
2057 244th Street, St. Croix Falls.
So you report to Burnett probation. They'll transfer it to Polk. Do you have a telephone number?
No,
You need to get a new phone?
yes,
Okay, and once you have a new telephone number, update the clerk's office as well as probation. If you move from your mother's address, not only do you have to update probation, you have to update the clerk's office here, okay?
yes.
All right. Nothing further than we are adjourned.
Judge, actually one thing, her phone was compensated by law enforcement, but there was never a search warrant done. There was never a forfeiture filed to keep that phone. So I believe that it should be released to her. I just want to make sure that
That's fine.
that she can get her phone.
I have to order it on the record all the time with every sentence.
That's fine.
Okay,
With everything that you
that's a
have to order.
Mr. Schmidt question. He can release it.
Have her go to the sheriff's office and ask for it. They'll send something to me and I'll say,
its way through the system. But Mr. Reynolds did not contact the child support agency to update employment, update any of the information he was supposed to update upon his release. He has not done that, which is why today's hearing remained on the calendar. I guess my request is for a $3,000 warrant with a condition of release that he also provide in writing all employment information, including an update as to his employment at the casino and at the A&H General Store.
All right.
And I would ask that we schedule the hearing for the next sanctions date I have no doubt that he will either be picked up or contact us upon learning about the warrant and request that hearing date. So we might as well get it on the calendar now.
I don't agree.
Okay.
Because if I put it on the calendar, he could do some little hiding until that date and time and come on in to court that day,
That's fair.
trying to avoid the warrant. Court is set for a reason, and it's set on a particular date and time that fits with the court's calendar, and the attorneys, as well as the defendant or respondent, and sometimes if there are certain things that come up. Mr. Reynolds has a notorious history for failing to appear, failing to come to court, and or failing to come to court on time. He is also significantly late when he does appear. The court is going to issue a warrant, $3,000 cash. Only judge may quash or posting of the cash. If he's able to post the cash, he'll be provided a new date and time upon posting. Another condition on that warrant is not only to pay the $3,000 on the face of the warrant, but also to update the child support agency of all employment information, including the casino and the A&H store, in writing before he is released from custody. Anything further, Ms. Thomas Schmidt?
No, Your Honor. Thank you.
All right, then we are adjourned. Well, this was fun. Okay. Real fun. All right, can Mr. Chapman and the jail hear me?
Yes.
Okay, now where is the jail? You're muted. Well, maybe they're not here yet. They're just setting up. There we go. Mr. Boone, can you hear me?
Yes, ma'am.
Thank you.
How are you doing today?
Good, how are you?
Doing all right. Doing all right. Thank you for asking.
All right. We will go on the record in the matter 19 CF 13, State of Wisconsin versus Javon Boone. The state appears through District Attorney Kevin Schmidt in person. We have Daniel Chapman, Defense Counsel, by video conferencing. Mr. Boone appears by video in custody in Burnett County Jail. We're set today in this matter for a plea and sentencing. Mr. Boone, do you understand you have the right to be here in person?
Yeah, I basically am, ain't I?
Yeah, no, well, you're by video conferencing, but you have the right to be here in the courtroom in person and have your attorney with you. Do you understand that, right?
Yes, I do.
And you are appearing by video, as is your attorney. And are you asking the court to allow you to enter a plea and be sentenced by video with your attorney by video as well?
Yes, Your Honor.
All right, thank you. If at any time you have any questions or concerns, or you need to speak with your attorney, let me know, and I'll send you both into a confidential breakout session, okay?
Okay.
And so, Mr. Chapman, I did receive a plea questionnaire waiver of rights form. It indicates that you went over this form by telephone with Mr. Boone. Did you thoroughly go over this document with him?
Yes, I did, Judge, every line.
And he is accepting the offer of an amendment to possession of amphetamine, and it would be a joint recommendation for time served and court costs. Is that correct?
That's correct, Your Honor.
Okay. All right, Mr. Boone, you are pleading guilty to a possession of amphetamine charge. Is that correct?
That is correct, Your Honor.
Mr. Schmidt, formal motion to amend
So made.
granted. I do have in front of me that plea questionnaire waiver of rights form, Mr. Boone. Your attorney has informed the court that he thoroughly went over that document with you. Do you recall him going over that document?
Yes, Your Honor.
And did he go over it thoroughly with you?
Yes.
And he went over it with you by the telephone, but are you stating on the record that if you had the ability to sign it, you would sign that document?
Yes, Your Honor.
Did he go over your constitutional rights with you?
Yes, Your Honor.
And do you thoroughly understand those rights?
Yes, ma'am.
Do you need me to go over those rights with you in any more detail?
No, ma'am.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that here the state would have to prove on or around January 7th, 2019, you possessed a substance, the substance was a controlled substance in an amphetamine classification, and that you knew or believed that substance was a controlled substance in an amphetamine classification? Do you understand what the state would have to prove?
Yes, Your Honor.
You understand the maximum possible penalty could be a fine of up to $5,000 or imprisonment of up to 1 year of incarceration or both.
Yes, Your Honor.
Do you also understand that there is a joint recommendation for the court to do a time served sentence? Do you understand I'm not bound to follow that recommendation?
Yeah, I understand that.
You understand that? Okay. So
I do.
if I thought the facts of the case warranted it and I thought it was egregious, I could sentence you to the maximum possible penalty or any other sentence that I think is appropriate. Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Now, did you go over the criminal complaint with your attorney? The
That's the
facts that are alleged there and what happened that day? Mr. Chapman, did you go over the facts alleged in that criminal complaint with Mr. Boone?
Yes, I did, Judge.
Okay,
Mr.
yes. All right, yes,
Disruptive.
yes.
We talked about how you were at the casino and they searched the car that you came in.
Okay, yeah.
ID. Okay, yes.
Yeah, I understand.
Okay, and for the most part, are those facts accurate, Mr. Boone?
Yes, Your Honor.
Are you admitting here today that you in fact did possess a substance in an amphetamine classification?
Yes, Your Honor.
And you knew it was something in the amphetamine classification?
Yes, Your Honor.
All right, so Mr. Boone, has anyone made any threats or any promises to you for you to plead guilty today?
No, Your Honor.
You're doing so freely and intelligently and voluntarily, knowing what you're doing?
Yes, Your Honor.
Are you satisfied with your attorney's services?
Yes, Your Honor.
Did he discuss with you the case and you discuss with him the case and from your standpoint?
Yes, Your Honor.
And so you're satisfied with his services?
Yes, Your Honor.
Do you have any questions for the court or for your attorney before I proceed?
No, Your Honor.
As
Besides,
to, oh, go ahead.
well, I'm not aware of what the court costs are.
Do you have the ability to pay court costs at all upfront?
I'm in treatment. I get general assistance and stuff. So like, I'm going back into treatment. So I don't really have a way. I mean, unless I get a job, I don't really have a way to pay, but I can find a way or something that, you know.
Okay, that's all good to know. But other than that, any other question?
No, ma'am.
As to amended count 1, possession of amphetamine, how do you wish to plead?
Yep.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of possession of amphetamine. The other count will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Schmidt?
The reason why we're doing this today is because this is a 2019 simple possession case. When I reviewed his record, I saw since 2019, he's already done probation and treatment in another state. So as it relates to the substance abuse issue he had in 2019, he's already made efforts to deal with that. Based on his statements, it looks like he's still dealing with that in another state. He's also, by my count, and Attorney Chapman, correct me if he disagrees, I think he's got 38 days jail credit, which is quite a lot. He's also forfeited way more than costs and fines across the course of this case. Thank you.
He has. Thank you. Mr. Chapman.
If it matters, I think he's got even more credit than that. Just on this most recent arrest, he was arrested September 10th and arrested in Minnesota and sent from county to county in Minnesota. But all of that was while also on a Wisconsin detainer for this warrant. I believe all of that time would count because he hasn't been serving another sentence up until now. And he just from that time, he's been held for 73 days by my count. But like I said, I don't think it really matters. This deal was negotiated with prior counsel. Mr. Boone is admitting that, yes, he knew the meth was in his car. There was another girl with him who was using a fake ID at the casino. And like the state indicated, he's not a resident of this state. He's still dealing with other charges and he's still on probation in Minnesota. So I don't think we need additional supervision in Wisconsin, Judge.
All right. Thank you. Mr. Schmidt, would you stipulate as to the 73 days held in custody?
If it's 73 just this stint, then it'd be 95 total.
Oh, yes. I was just counting from the time he was arrested in Minnesota on this warrant.
So he's actually sat 95 days in custody.
He had 22 days credit prior to this recent stint. So I just added 22 on to the number Attorney Chapman gave.
Okay, thank you. Mr. Boone, is there anything that you want to say, you want to tell the court?
No, thank you, Your Honor.
Okay, thank you. When you're not in custody, are you at that apartment 101 on Lindale Avenue North?
No, that hasn't been my address since 2019.
Do you have an address where you receive mail at least?
Yes, I do.
Can I get it, please?
It is 328 6th Street, Southeast Minneapolis, apartment 305, zip code 55414.
55414. And do you have a telephone number when you're not in custody?
I've been in custody for a while, so I don't have my number anymore. I didn't get arrested on do I need to have an updated? I can give you like my I can give you my son's mom's or
That would be great.
the number is 612-403-9813.
Excellent. If we need to, can we send that phone text messages?
Yes.
Okay, thank you. All right. I think that the agreement is appropriate. You've sat a lot of days in custody on this case because it's been since 2019 and it's been warrant and then you abscond, or warrant and you abscond, or you've been in custody somewhere else or in treatment or something, and you haven't made your court appearance here, but then you've been in custody in Minnesota waiting to come back here. I think that it is appropriate that because you've sat so many days, I'm going to order 120 days of jail with 95 days of jail credit. That means that's a time served, okay? So I'm going to give you the credit that you deserve for the time that you've sat. So 120 days jail sentence, 95 days of jail credit, again, a time served. I'm going to give you a break on the fines and fees. I should be assessing $443, but I'm going to waive $243. I'm only going to order $200 DNA surcharge, and that is a mandatory assessment that I cannot waive. I am going to say that you need to start making payments as of January this next year. And it'll be payments in the amount of $25 until paid off in full. You need to make your payment, or you need to contact the court and let me know why you can't make that payment if you're having a significant or substantial financial hardship. You need to contact the court, okay? Otherwise, a warrant will be issued. You could sit up to 6 months in jail.
Your Honor,
Yes,
can I say something, please?
you sure can.
So I'm going to be in inpatient treatment until February. So is there any way we can make it where I start paying after I get out of treatment? I mean,
When are you being released in February?
I don't know exactly, but it's a 90-day program. So,
All right, I will say first payment in February. That gives you until the last day in February to make $25. So you should be
Okay.
able to figure out $25, even if you're released on the 20th of February. You can borrow it and pay it, or you can write a letter to the court. But again, Mr. Boone, it's very important that you make at least your $25 a month payment, or you pay that $200 off in full as quickly as you can, because I will issue a warrant. You see what happens when I issue a warrant. You sit in custody for a while. You could sit up to 6 months in jail for not paying. It's, again, very important that you pay this. Not only could I issue a warrant and you can sit more jail time, but I would issue a civil judgment against you, because you're always going to owe that. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. The jail will make sure that we have that. You have the ability to request it be expunged through a written letter to the Department of Justice. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Chapman?
When we're done, can I go into a breakout room with Mr. Boone to discuss his?
Very quickly, you may, but I need that jail for my next hearing.
I will be
So-
quick.
Thank you.
Nothing else.
all right, thank you, Your Honor.
You're welcome. There you go. I opened the room.
I clicked the wrong button, I think. There we go. Found it.
Mr. Boone, there you go.
That reminds me, if you have any
Mr. Felisky has filed Kevin Schmidt. Is Vicky coming down?
No.
We will go on the record in the matter 25 CF 158, State of Wisconsin versus Luke Beechler. The state appears through District Attorney Kevin Schmidt in person. Mr. Beechler appears by video conferencing in custody in Burnett County Jail. We do have his counsel, Joel Felisky, in person. We're set here today on a motion hearing, a four corners motion. Mr. Felisky has filed his motion. I don't know if he filed yesterday or this morning, but I just got it this morning and I reviewed it today or this morning prior to this hearing. And I'll allow you to argue off of it, but I mean, I did thoroughly read it, so.
Of course, Your Honor, and I don't see the need to repeat myself endlessly on it. I think it's fairly straightforward here. Under Wisconsin law, I'm sorry, early morning, whatever. I'll begin. I appreciate it, Your Honor. Sorry, I'll begin again. My main point here is looking on a case, State versus Godesi, 112 Wisconsin 2D 213. In that case, there was a similar challenge to the sufficiency of the complaint based on the facts that were alleged in that complaint relating to intoxication. The court found against Mr. Godesi on the basis that the complaint did reference numerous indica of intoxication, the odor of alcohol in the breath, slurred speech, poor balance, the inability to perform preliminary breath tests, so on and so forth. In this case, Your Honor, the only indication in the complaint itself of any amount of intoxication is Deputy Anton's observation that Mr. Beechler had the odor of alcohol on his person, but there were no standardized field sobriety tests performed. There was no preliminary breath test performed. There was a blood alcohol sample that was taken from Mr. Beechler with his consent at Burnett Medical Hospital, but those results, and assuming they're probably still pending, are not included as part of this complaint. Your Honor, I think the state would likely rely on the statements made by Mr. Beechler to law enforcement, but in reference to those, my concern would be that they're speculative. Mr. Beechler doesn't indicate that he really only indicates that he felt that he couldn't have passed a preliminary breath test at that time. I think in consideration of the law here, requirements for a motion to be, complaint to be sufficient within the four corners requires some indication here when it concerns operating a vehicle while intoxicated that the operator actually is intoxicated, and there's just not facts here that are referenced in the complaint that would indicate that, other than, again, the admission, which is speculative by Mr. Beechler, and again, somewhat speculatively here, but the theoretical results for the blood alcohol content in his blood, which are again not included in this complaint. I think the complaint here, because of those lack of facts, is insufficient. It doesn't state why Mr. Beechler in particular is being charged with the crime of operating while intoxicated, and I'd ask the court to dismiss this complaint. Thank you.
Isn't one of the distinctions between the facts alleged here in State versus Gaudesi, and that's Gaudesi, that case in the State versus Gaudesi, there wasn't the statement made by the defendant that he believed he was intoxicated, correct?
That is correct, Your Honor. But again, I think the issue here is that this is, again, speculative. Looking at the complaint, the specific language there, it's actually in bold. Mr. Beechler states, quote, he would not pass, and then stated he would be above that. So again, these are very broad statements, Your Honor. They're vague here. He's not indicating really any amount of intoxication, any level. He's just making the presumption, frankly, to law enforcement that he would not be below the legal limit.
Okay, Mr. Schmidt.
The test of a complaint is of minimal adequacy in setting forth the essential facts, establishing probable cause through a common sense and not hyper-technical evaluation. State v. Maxwell, 2000, WI App 112. The defendant argues that the complaint does not allege that there is sufficient facts to probable cause that he was intoxicated when he operated a motor vehicle. More specifically, that element of the offense is whether he lacks the clear judgment and steady hand necessary to operate a motor vehicle, where the pattern jury instruction goes on to say that whatever that is, that standard, if you're less than it by any, then you're below it. The complaint alleges that at 1 a.m, Luke Beechler left a bar, struck a human being with a motor vehicle, said he didn't see how he struck the being, just said car in front of him swerved and suddenly he hit something. He had an odor of intoxicants about him. He refused to do a field sobriety test. He refused to do a PBT. He said the reason why he's refusing to do those is he knew he'd be over the limit. A complaint alleges that he knew what the limit was. There was a discussion about that. Using common sense, it is not speculative when a person says, I think I'm going to be over the limit, because we wouldn't think, hey, he did a PBT on his own beforehand. We think the reason he said that is because he has firsthand knowledge of how he feels, which is why he said that. We've had numerous cases since 1983 that talk about just refusing fields, just refusing the PBT is itself evidence of consciousness of guilt. Here we actually have the defendant articulating, yes, that is the exact reason I am refusing. I have consciousness of guilt. I think it's going to be bad evidence for me. And the reason why is because he knows how he feels. It is not speculative if I said, hey, I have a dry and scratchy throat. I think I might be getting sick, for me to say that, because I'm basing it on my subjective experience, even though I haven't gone to a doctor. This is the same, I think, under the common sense standard and not the hyper-technical. This establishes probable cause. Thank you.
Thank you. Mr. Felisky, I do believe that you're vigorously arguing for your client, and that you did a good comparison with the State v. Gaudesi case. However, the main fact that is different between those cases is the fact that Mr. Beachler did make those statements. He did make the statement, and I will read it exactly how it is in the criminal complaint, as you have done. He stated because he would not pass, he stated he would be above that, which is he would be above the legal limit of Wisconsin of 0.08. In the Four Corners motion, Mr. Beachler, so that you can understand that it is probable cause, and the court has to look at all of the things that are stated in the Four Corners. That means all of the words on the documents on those pages to determine whether or not a crime was likely committed, probable cause, and it's likely to have been committed, or probably was a crime probably committed. And this isn't the step where the court determines whether or not a felony was probably committed, just a crime was probably committed. Based upon the information contained in the criminal complaint, the court does find that there is probable cause that a crime has been committed. Therefore, the court is denying the motion. Mr. Felisky, I believe you filed another motion to be heard on bond. Are we in victims' rights compliance? We
Yes.
are. So we can argue that here today, Mr. Felisky.
Very good, Your Honor. Again, I won't regurgitate my motion here. I think it's fairly straightforward. Mr. Beachler is not able to satisfy the amount of cash that's been requested by the court for posting bond. I believe it's set at about $15,000 cash right now. He is indigent. He was, prior to his incarceration, employed full-time in the community at Injection Molding Solutions here in Siren. Your Honor, I'm sure as the court is very well aware, the primary factor for setting cash bail is how much it will take to compel the defendant to come back to court. It's my understanding here, based on the facts and circumstances, that Mr. Beachler actually was the reporting party in this incident, despite having been the one, having allegedly, struck this individual. He took it upon himself. He took upon that responsibility to immediately contact law enforcement. I sincerely hope that may have had a substantial impact in the medical situation of the victim here. I think that in some ways may have been crucial. I'd also note that Mr. Beachler doesn't have a criminal history here in Wisconsin. I did take the liberty of reviewing his previous place of residence in Arizona, where I believe he got his first OWI. However, that history is incredibly limited, Your Honor. I think it only consists of a few traffic matters. I don't think there's any indication here to suggest that Mr. Beachler, considering the circumstances of this case, would not be compelled to come back to court. However, I do think that the seriousness alleged here would warrant some cash, just not the amount of $15,000. Considering of all this, Your Honor, I would ask for the court to modify this bond down to a $1,500 cash bond with the same non-monetary conditions. Thank you.
All right, thank you. So if I'm hearing you correctly, because I did read your motion to modify bond as well, and quite honestly, I love how attorneys put it in that he does not have a criminal history in Wisconsin, except for the current charges, or his criminal history in Wisconsin is limited, because he could have a significant history elsewhere. That has to come into play. So I do have to consider criminal history outside of Wisconsin as well. But if I'm hearing your argument correctly, it's his criminal history is extremely limited, just simply an OWI in Arizona and perhaps some traffic.
That was my understanding, Your Honor. I'm not familiar with Arizona's case citations and whatnot, but doing a brief review of their public record search for the courts, those were the results that I came across.
Okay, thank you. Mr. Smith.
I agree that bonds should be reduced. I would pause on doing as low as 1,500. I'd ask the court to consider something like 5,000 for a couple of reasons. First, he has only one criminal conviction. It is Arizona. It is something called extreme DUI. I think they just call it that based off the BAC level. The other traffic things are not criminal in Arizona. So he has one prior conviction. It's in 2021. As far as I can tell, he never got a warrant for failed appearance there. He's got no priors in Wisconsin. The main reason why I'm asking the court consider a lower bond here, but still keep some cash is a lot of times I come here and I say, hey, judge, based upon the seriousness of the offense and the strength of the evidence, certainty of conviction, keep it what it is. In this case, the nature of the injury is extremely serious. Quite frankly, it's great bodily harm. The victim is hard to interact with because they're still in the hospital and still very addled. In this case, the probable cause, you probably noticed when the arrest happened, said, Mr. Beechler said that a vehicle in front of him swerved, he hit something, he stopped, saw it was a person, called help. The court my argument today was consciousness of guilt is why he refused to cooperate with PBD and testing. So he had enough consciousness of guilt to know he was intoxicated, but he still helped this person. If he kept driving and sped off, he could have killed this person. And also we had another person later we interviewed at the bar who said the victim left the bar, went out, and then a white SUV hit him, and then he was hit by Mr. Beechler, and then that first vehicle sped off. Mr. Beechler has been cooperating with law enforcement to help us try to find the other vehicle that also hit the victim. I think that should show some cooperation and collaboration. The main reason why I'm asking to go as low as the defendant's asking is I'm real dubious about the connection to Wisconsin. I understand that he's saying he has a job here, he has family here, that he's living here right now. The OWI in Arizona was just in 2021. In this incident, his driver's license is still an Arizona driver's license. It's still an Arizona registered vehicle. I'm concerned about how much his roots are actually here in Wisconsin versus Arizona. That's my main concern about this case at this time. Thank you.
All right, thank you. Mr. Beechler, when did you move back to Wisconsin?
February.
In February? And am I remembering correctly from another hearing that I'm not sure if I'm remembering correctly, but you were a graduate of Webster High School?
No, I'm currently in the 509 GED program.
Oh, okay. But you lived in Wisconsin sometime?
No, not prior.
Oh, so you just moved here from Arizona?
Yeah, I was waiting to get, sorry.
No, I must have been reading, or it must have been something about the victim with Webster or something like that. Okay, all right. So you've been here since February.
Yes.
We're going on a year. You don't have your driver's license changed over. I'm going to guess you don't have your vehicle changed over, which quite honestly, FYI, you have to do it. If you're planning on residing here, it needs to be done within a certain amount of time, really short amount of time, 30 to 60 days or something of that nature. But that's neither here nor there. You are working and that's good. And you have family in the area. I do give you kudos. You are working with the police, or you have been, and you did call immediately. You could have fled as well, like the alleged other vehicle, and that could have had a much bigger impact and effect upon the victim here. So you were doing the right thing, and you continue to show that you want to do the right thing, even understanding the severity of this charge against you, which is a Class H felony that could mean a $10,000 fine, or it could mean 6 years of incarceration, 3 of initial confinement, and 3 years of extended supervision if convicted. Again, those are the maximum possible penalties. I do understand, and before Mr. Schmidt even made his argument, hearing the argument from your attorney and those positive things, the court was in the mindset of modifying and amending bail to be in a lower amount. even still the $1,500, I need to assure your appearance, and the fact that you have not done the other things to show that you are going to be a Wisconsin resident, you don't have a home that you've purchased, I don't have any lease that you've signed for a period of year, I don't have your vehicle transferred to Wisconsin. I don't have that your driver's license has been transferred to Wisconsin. So there is still significant risk and cause for concern that you are going to make all court appearances, even with a lack of criminal history other than one OWI. So the court has to be concerned about that. So I am going to modify bond from the $15,000 cash down to the $5,000 as requested by the state, as that is an appropriate amount. You have the ability to continue to ask for a modification down the road if some things can change or there's more showing of the court that you wouldn't be a flight risk. You wanted to say something, Mr. Beechler?
Yes, the reason why I hadn't had my driver's license changed over is because I was waiting on a copy of my birth certificate from Arizona. I had scheduled a day off of Thursday, the following Thursday from the day of the accident, to go get my license changed over. I have my address changed over with the Department of Motor Vehicles in Arizona, which is why I was not able to get a temporary tags on my registration up here in Wisconsin. So I was just waiting for my license to get my license so I could get registration on my vehicle.
I understand that argument, Mr. Beechler, but so you can understand where I'm seated and
Yes.
what I hear all the time. I was going to do it the day after the accident happened. I just got a job, Judge. I'm in custody,
Yes,
and I was to start yesterday. So I hear that all the time. And I'm not saying that you're not a believable or trustworthy person, but seated where I am and the fact that I hear those all the time and the fact that it's been since February, almost a year, yeah, I hear you and I understand that. And I appreciate what you're saying. I still have cause for concern that you're going to appear for court, especially considering other than what's stated in the complaint about where the victim is with the health and medical issues. That's all I have. I don't know if things could get worse. I don't know if things are only going to get better. But I have to go off of what I have. And so the court will amend to $5,000 cash, same conditions. Would you like to get another date? Do we have to have a prelim? Is that what we need?
Yes, Your Honor, I think we still have to go through the initial, but I think we
Okay.
can do that.
Oh, that's right, an initial appearance. So did you go over the criminal complaint with Mr. Beechler?
Yes, Your Honor. I believe he understands the charge here and the maximum penalties. We'll waive formal reading, and we'll also waive time limits for setting the prelim.
Okay, let's get the matter set for prelim. I could do 11:45 on December 8th.
That will work.
December 8th. And Mr. Schmidt, so I am aware for scheduling in the future, is this going to be your case or Mr. Vilas?
It'll be mine, but it's fine that was scheduled in his week because he's in custody.
Okay. All right. Thank you. We will see you then. I know you waived time limits. I just wanted to make sure this is a serious case. He's asked for a bond modification and I want to be able to have a quicker turnaround.
Certainly, Your Honor.
That's why I scheduled it when I did. All right. Anything further?
Not for me.
Then we are adjourned. Thank you. It looks like Mr. Schmidt needs to talk to you and then Mr. Matrius. State of Wisconsin, County of Burnett versus Peter Mulroy. The state appears through District Attorney Kevin Schmidt in person. Mr. Mulroy appears in person with counsel, Mr. Joel Feliski. We're set for this plea and sentencing. The parties have reached an agreement. We were just here on the 19th. But for the record, Mr. Feliski, can you recite the agreement again?
Absolutely, Your Honor. The parties have reached an agreement here for Mr. Mulroy to plead to count 1 in the complaint at 25 CF 116. The state has agreed to amend that down to, I have here, a failure to stop for law enforcement as a misdemeanor, the statute being 346.042T. There's a joint recommendation here. Apologize, I got a little ahead of myself. The traffic matters along with 25 CT 43 will be dismissed and read in, and there's a joint recommendation here between the parties for a fine inclusive of costs, $1,000. I have a completed plea questionnaire with me. May I approach?
You may. Thank you, Mr. Feliski. And I appreciate, but I know the clerks appreciate it so much more when you recite the statute on the record. So thank you. All right. So I have in front of me the plea questionnaire and waiver of rights form. I do understand the facts alleged in this case, along with there was a co-defendant involved. Mr. Schmidt, formal motion to amend to the misdemeanor version.
So made.
Granted. Mr. Mulroy, I have in front of me this plea questionnaire waiver of rights form. Do you recognize the document?
I do.
Did your attorney thoroughly go over the document with you?
Yes, he has.
Did he read it to you essentially word for word?
Yes.
And you understand everything completely?
Yep.
Did he thoroughly go over your constitutional rights?
Yeah.
And you understand them completely?
Yep.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yep.
Is that your signature on the second page?
Yep. This is.
Now, do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yep.
Do you understand here? The state would have to prove on or around August 8, 2025, you operated a motor vehicle on a highway, you received a signal to stop your vehicle from law enforcement, you knowingly resisted the officer by failing to stop the vehicle as promptly as safety would permit. Do you understand what the state would need to prove?
Yes.
You understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
Do you also understand that there is an agreement here where there's a recommendation for the court to accept a costs only sentence? Do you understand I'm not bound to follow that?
Yes.
I could sentence you all the way up to that maximum penalty if I thought it was warranted?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint with your attorney? That's that document where it basically says what happened that day and why you were charged with crimes?
Yes. I
For
have.
the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did fail to stop your vehicle as promptly as safety would permit?
Yes.
And you knew that an officer was asking you to pull over?
Yes.
Mr. Feliski, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you for you to plead guilty?
No.
You're doing so freely, intelligently, and voluntarily?
Yes.
You fully understand what you're doing today?
Yep.
Has your attorney represented you competently?
Yes.
He's answered all of your questions?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No.
Then as to the amended count 1, a misdemeanor version of failing to stop your vehicle, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count. All of the traffic matters and other cases will be dismissed and read in for purposes of sentencing. Again, congratulations on getting your license.
Thank you.
That really is truly awesome.
Thanks.
A judgment of conviction will be entered today. Argument, Mr. Schmidt.
Yeah, Mr. Mulroy, I believe this is his first criminal conviction. In this case, there was truly no reason for him to flee from the police. It looked like Dakota fled because he had a warrant, and then he just did because Dakota did. So there's really no criminogenic needs. It was kind of an impulsive bad decision in the moment. To that end, I thought doing the $1,000 fine inclusive of costs would be appropriate in this case, aggregating all those traffic tickets into one fine. I didn't think probation would make no sense, which is the first thing we have to consider because there's no criminogenic needs. And given the lack of history and the nature of this, again, just a bad decision for no reason. I didn't think jail would be necessary either. Thank you.
Thank you. Mr. Feliski.
Thank you, Your Honor. I do first want to address the issue of any custody credit. I see that based on CCAP here and the complaint, Mr. Mulroy was brought into custody on August 8th of this year. It seems that he posted bond and was released on September 5th. By my math, that equals 29 days of credit. Your Honor, I do agree with the state here. I think this is an appropriate resolution. Mr. Mulroy has been very clear with me that he agrees that that was a poor decision on his part, and he certainly does not intend to repeat it in the future, nor to frankly make any other decisions that would bring him back before this court or any other. I think that the substantive amount of this fine, $1,000, is no small amount of cash, especially in these times, Your Honor. This is sufficient deterrent towards any further behavior. I agree with the state that I don't think there's a criminogenic need that needs to be met here. Overall, I think that this is an appropriate agreement. I'd ask the court to follow it. Thank you.
All right, thank you. Mr. Mulroy, any statement you want to make?
No,
And I believe you've prepaid, haven't you?
I believe so, yes.
Excellent, good. Mr. Mulroy, as Mr. Smith said, you had no reason to run or to do anything. And I don't know why, and I'm sure it's the adrenaline that's pumping and
Yeah.
seeing law enforcement and just going,
Yeah.
but now you know you cannot, if you've done nothing wrong, don't worry about it. If you get stopped, then they'll just let you go.
Yep.
And I mean, really, that was it here. That was it.
Yeah.
So you have your driver's license now, which I am so thankful for. So
Yep.
thank you for getting that, because then now you're going to not have to worry, and not because that could have been your, I don't know if you had it, you didn't have it by then, did you?
When I got,
Pulled over?
I had it at the time, and then afterwards it got taken away for a month or whatever. So
Don't do this again.
no, I don't plan on it.
Don't do it again. You're a good young man.
Yeah.
And you're trying to, live a good, stable life.
Yeah.
So keep that up.
I will.
$1,000, that'll hit hard.
Yeah.
You've already figured out how to come up with it, especially I think you said you're on disability.
Yep.
And so that hits you even harder.
It does.
I know you can work on disability. I don't know the limitations or whatnot.
Yeah.
I'm hoping that you're going to be out there doing something so you can keep yourself active.
Yeah.
Because that'll keep you out of trouble.
Mm-hmm.
So what the court is going to do is, I am going to sentence you to 30 days in jail, 29 days of jail credit. It's a time served. You've sat the time.
All
It should
right.
at least be on there to show that you sat the time,
Yeah.
because that was a punishment.
All right.
And had I known all of these other factors and all of these other things, that's a long time to sit when you left when you shouldn't have left,
Mm-hmm.
and you had nothing to leave for. So 30 days of jail, 29 days of jail credit. So that's a time served with good time, et cetera. $1,000 fine. You've already prepaid it. That's good to go. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. When you're done here, you're going to need to go to the jail, to their booking, and you're going to need to provide your DNA. If they need it, they'll say, yep, and they'll swab you. If they don't, they'll say you're good to go and free to leave. You have the ability to request that your DNA be expunged from the system through a written letter to the
All right.
Department of Justice, not to this court, but to the Wisconsin Department of Justice. You can Google it. It's easy, or Mr. Feliski can help you if that's what you want to do, okay?
All right.
I think that covers everything, Mr. Schmidt.
Nothing for me.
Mr. Feliski.
Nothing further. Thank you.
All right. Good luck to you, Mr. Mulroy.
Thank you.
The state appears through District Attorney Kevin Schmidt in person. Ms. Gangelhoff appears in person with counsel Joel Feliski. We're here today in this matter because Mr. Feliski has filed a motion to withdraw. He has indicated that there has been a breakdown in your communication, Ms. Gangelhoff. In a hearing like this, the court needs to know certain things as to the relationship to determine whether or not to permit a withdrawal. I understand, and so you can understand it. Mr. Feliski is in a bit of a quandary because his job is to keep your conversations and communications confidential. So he will not say anything that would release or break that confidentiality, okay? Unless you give him the ability to do so. I want to hear from you to see what your perspective is and why you think there's been an irretrievable breakdown of communication.
Because he's been lying to me this entire time.
I don't want to, yeah, I wouldn't say that.
I would. I mean, he's completely lied to me this entire time, telling me something that isn't true, telling me that this driver's license business was not going to be a problem. It's okay. Just give up your preliminary hearing. It'll be all right. And I don't know what to do with that.
What I'm hearing is that you may have a different understanding of the facts and the law and how it affects, and that's fine. And I'm hearing that you believe he may have told you mistruth or untruths or mistruths.
Yeah, or led me to believe, something just simply wasn't true. Either he didn't have the information to make the claim in the first place. Like it was a problem. It is an issue. And 7 months later, you're going to.
Your driver's license?
Yes. Which I told him day one.
That you can't get it?
Yes. And it's okay. It's okay.
Well, then
it's not okay.
If you can't get your driver's license, then I'm going to tell you, you were cited with operating without a valid. I don't know your criminal history. I don't know if you've been cited with that before, but I am going to strongly encourage you. I'm not going to order you.
Yeah.
But I'm going to strongly encourage you not to drive without a valid driver's license. You could get into a lot of trouble down the road. Part of the offer was, if I'm recalling correctly, get an AODA assessment and do that follow through and then get your license if you reinstate your license. Well, with operating without a license, you've never had a license.
Well, it's expired only in Wisconsin.
Okay.
That's it. But I must have waited too long. So now
you have to do everything.
Well, they check the other surrounding states, they'll check the Minnesota. My Minnesota is not good, so they won't probably, but I haven't even ever asked. I mean, I've been trying to deal with Minnesota this whole time. I've never gone into the Wisconsin DMV and just tried to renew my license,
I'm going to tell you, you won't be able to renew your license in Wisconsin until you take care of Minnesota.
And that's where I'm at. And I can do that, but not, not for a while. And it's going to take a lot of money. So.
Well, and here's the thing, that whatever, you get to accept an offer you wish to accept, or we can set the matter for trial, but you're facing a felony and 2 misdemeanors.
Exactly.
So I'm not going to get into the ins and the outs about any offers or any negotiations or anything of that nature, but I am going to tell you that there is an offer out here for the assessment, get that complete, do the follow through, and then reinstate your license. And then it would be to plead to a THC for costs, I believe.
Exactly. That's what I been trying to do, because he keeps reassuring me that the license will not be a problem. But now it is.
I'm not going to ask you what he's saying with that, because there's multiple ways that can be inferred. And whether or not you get your license or you don't get your license, Mr. Schmidt, is there an offer without her getting her license? Because it sounds like she's having a difficult time getting her license.
There is an offer.
There's been a few. It's just, I've always presumed she could get her license.
Well, and what I'm hearing today is it's difficult for her. She has to go through a couple states. So do you recall the offer without getting your license?
Not exactly.
I never made one.
Okay.
No, Your Honor, I do want to correct. There was an alternative presented by Mr. Schmidt, which I did relay to Ms. Gangelhoff regarding this case. I'm going to pull up that email right now. It's an offer to plead to 1 count of operating after revocation, 1 count of misdemeanor amphetamine for costs on each.
Okay, and don't get into the ins and the outs of that. That's just the offer that's presented by the state. And again, that's your call to make if you wish to accept or reject any offer. And it's only for your attorney to relay to you what the offers are and pros and cons of each. But I'm hearing that there has been a massive breakdown, and I would say irretrievable breakdown in the relationship, in the communication. I'm not even going to go through all of the other factors because I looked, these charges arose out of April 2025. Mr. Flisky has been your first public defender. So you can understand, though, that if the court is going to allow him to withdraw, but you'll be appointed a new public defender. You don't have, if this happens again, I will go through all the factors, and quite honestly, the fact that I'm hearing that you're saying that he's lied to you or all of those other things, that you have opened up the can of worms where he can spill his guts about all of the conversations and exactly what he's said to you and what you've interpreted of what he said to you without breaking confidentiality. But I'm not going to make him do that if he doesn't want to, because I'm just going to allow him to withdraw. So if you come back and you have another public defender and the same issues are occurring and you're saying that they're lying to you, whatever, that can of worms will be opened. They will be able to respond to those accusations, okay?
Okay.
Because I'm going to let you know on the record, Mr. Flisky, he's been practicing in front of the court. I don't know if it's been a full year now. He's been doing a fabulous job. And so it's hard for the court to believe that he would be outright lying to you or telling you mistruths. Okay?
Okay.
It just seems like there could be a different interpretation from what you're hearing versus what he's saying versus what the law is versus what an offer is from the state. And as I've heard now, there's 2 offers. There's one offer that's a really smashing good offer perhaps, and there's another offer that is based upon if you can't get your driver's license, and that's for the state to do. Or the state can withdraw all offers and say we're going to court or we're going to trial and we're going to face these all right now and set them. So you have plenty of options to consider. And Mr. Flisky will be notifying the public defender's office that you are now in need of another attorney. Another attorney will be appointed, and you will go through the same things that Mr. Flisky has went through with you, the facts of the case, the offers that are made, and you will tell this other attorney what you found out about your license. And what it's sounding like here today is it's, I don't want to say impossible for you to get your license, just difficult.
Mm-hmm.
And so that can come into play with an offer, but the court, I'm sorry, I'm not going to wait 6 months or a year to wait until you get your license before these cases are set for trial.
Yep, I understand.
Okay, so the court is going to sign the motion to withdraw. And you'll be able to get another public defender. But again, I do have to let you know that when you say accusations like that, that does open up the ability for the attorney to be able to respond to those accusations. And you are indicating that, I mean, it's a break of confidentiality on your part by saying, because he's going to have to respond.
Yeah.
I guess I never asked you, would you like to respond? I wasn't going to put you in the hot seat.
Your Honor, out of respect for the confidentiality of our conversations, I'm not going to respond.
Okay, completely understood. All right, so let's get another date and time.
I just want to say, I want to get this, settled as quickly as possible, as much as anybody. And, this whole business was news to me too.
I'm glad to hear that you want to resolve it. I'm glad to hear that you're doing all of the things that you need to